on muawada. Someone gives you a gift, what do? You give them a gift. يعني تهادوا تحابوا. But does that remove the meaning of it being a gift? No. So bila iwad, that's mentioned here, is a bila sharti iwad. Without the condition of that. طبعا الهبة المشروطة بمال is بيع. If I say, I gift you this phone for $5,000, for $500, right? الهبة المشروطة بيع. Right? Is a sale. Because what counts is المعنى. وتصح بالإيجاب والقبول. It is valid with offer and acceptance. Now, the ulama made a detail on this, right? 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 That تصح it's valid with ijab and qabul. The integral of the sale of the hiba, of the gift, is the offer from the one who, the offer of the one gifting. Right? الإجاب من الواهب شرط والقبول ليس is ركن والقبول ليس ركنا استحسانا. The qabul does not have to be a rukn. Why? And we'll see. Right? And that's why he says تتم بالقبض, and it is completed with qabd, with taking possession. Right? وتتم بالقبض, and it is completed, the gift is completed by qabd. Right? And in the Majalla, item 841, he tells us, they tell us, right, that the qabd, taking possession, وهو فيها كالقبول في البيع, and the taking of possession in gifts is like the qabul, is like the acceptance in a sale transaction. And the reason that it's completed by qabd, right? Because لأنها من التبرعات, because it's from عقود التبرع, وهي لا تتم إلا بالقبض. And the contracts of tabarru', of the contracts that are of non-exchange, where there's only consideration from one party, they're only complete by taking possession. Lending is the same, loan, etc. It's only when possession is taken that it becomes binding. And we'll see the examples. And by taking possession, the possession is either بالقبض الحقيقي أو الحكمي. Right? Right? So in the Tanweer it says وَالتَّمَكُّنِ مِنَ الْقَبْضِ كَالْقَبْضِ. Right? Allowing someone to take possession of it is like they're taking possession of it. Right? And this is بالتخلية. Right? It's mentioned in the Durar that والمختار أن القبض يحصل بالتخلية. And the chosen opinion is that taking possession happens either actually, this is called القبض الحقيقي, actual taking of possession, take my phone, right? Or بالحكمي, which is بالتخلية, which is برفع الموانع عن القبض, which is by, this is not the عبارة of the So takhliya is when the takhliya is برفع المانع. There's nothing preventing the person from taking it. Right? So for example, if my pen is in my sleeve and I'm sitting like this, I say, you can take my pen. Would you take my pen? No, because most people would not go and grab it from somebody, right? But if I put it on the table, this pen is for you, you can take it. And I put it there, is there anything preventing you from taking it? No. That's considered qabd hukman, effective taking of possession. There's also item 763 of the Majalla, 763 of the Majalla, that نهي الواهب الموهوب له عن القبض بعد الإيجاب رجوع. That if the one who's gifting prohibits the one receiving the gift from taking possession of it, is a going back on the gifting, right? So I say, you can take this pen. So you go to take it, I said, no, not now, right? I just said, don't take it now. This is a going back on the gift. It's a useful fara to be aware of, because very often your gifts are one of those wobbly things that people aren't clear about. Here, before we jump into the section, because we try to connect this to the practical ethics of Islamic law, frequently, especially in family, it's not clear, even amongst friends, it's not clear that when is something a gift or a lending or a sale or a hire, depending on the type of item, right? Because never underestimate the possibility of a aqd fasid. Some say, beta, you can use my car. And the person didn't tell you that they were using it for their nephews and nieces to drive as an Uber car. You can use my car, I meant you can rent it. Oh, you say you can have my car to use. You can have it as a gift, or am I renting it from you? Or are you selling it to me? They're all possibilities. It could even be zakat, right? Here's my car. Someone could intend zakat bil-ayn, right? And in the current market value, with caution, you can give a car as zakat, for example. It has to be at the real current market value of it, not how much you got it for, etc. So what is it? Right? So tabayyan, and to be clear about that, this is important, right? Okay, we've talked about that before, but we have to keep these things in mind. Okay. So التتم بالقبض is completed by taking possession of it. So he says, فإن قبض الموهوب له أي الهبة في المجلس بغير أمر الواهب جاز. Right? If the one whom the gift was directed towards takes possession of the gift in the majlis, in the gathering where the gift was initiated, even without the one gifting ordering them to take it, it is valid. And this is istihsan. Good. As long as they didn't, walam yanhahu, right? And they didn't forbid them, right? For what we mentioned below, right? The item 7th, right? 763, right? That if he takes possession of it, say, you can take my pen. Said, my iPad is for you. He says thank you, and he takes it. I don't have to say please take it, right? As long as he didn't prohibit him. Why? Majalla item number Did I say 700? It's actually 800. 863. My apologies. I'm bad with reading numbers. And 842. Right? It says يلزم الإذن يلزم إذن الواهب صراحة أو دلالة في القبض. Right? That the permission of the gift of the one gifting to take possession is required either explicitly, where they say, yes, here it is, take it, or dilalatan, or by indication, which is عدم النهي. بالتخلية وعدم النهي. They didn't put any preventative from it, right? And they didn't prohibit you. Okay. Because the offer of, this is for you, indicates permission normally to take it, right? إلا أن يأذن له الواهب. Okay, sorry. وإن قبض بعد الافتراق لم تصح. But if the offer of gifting was made to takes possession of it after they parted, this is not a valid gift. إلا أن يأذن له الواهب في القبض, unless the one gifting gives them permission to take it, because of the possibility that they'd go back on it, because it's not complete, right? So I said, like, I made this big can you grab me that other fountain pen, because it's a real case, right? So I have this really nice fountain pen, right? So I said, Omar, I gift you this fountain pen. You can take it. And you don't. And you go away. And let's imagine you go away. I said, he doesn't want it. I just take it back. Right? So the اعتبار المجلس, the gathering, counts. I could go back. Because the offer, less like in a sale. I sell you this for $10. Is that offer an eternal offer? How long does the offer last? By default? The majlis. Of course, there's a separate thing of what's called a standing offer in sales, and those are considered in our times. That's an opinion in the Hanafi madhab, and fatwa is given on that. That things like emails, if something is set up for instant sale online, that's considered, or for example, if there's a vending machine, right? That's considered to be a standing offer, right? It's continued as long as they don't retract it. So you don't have to accept right away, right? So if you get an email, you don't have to respond right away. You think about it all day. Next day you say, I accept your offer. It's valid. Unless they retract it. You can see the details. That's actually, it's mentioned in the commentaries on the Majalla. Atasi mentions it, I think from the Bazaziyya and others. That's a narration from, I think, Muhammad al-Hassan or whatever. And it's there. It's discussed by Mufti Taqi Usmani in Aqd al-Bay' or Fiqh al-Buyu'. Sorry, Mufti Taqi's book. Okay, but that need does not arise in a gift, right? But if I said you can take this, and I put it here, you got up, left the class at night, you came and you checked. Oh, cool! It's actually nicer than I thought. You took it. Then, what happens? Is that an acceptance of the gift? Not technically. Right? This would be a tasarruf fuduli. You're acting without permission. When could you accept? When could you just take it without seeking my permission? If you are reasonably sure, that the person wouldn't mind. Right? But let's say I did this whole spiel. Please take this pen. I'd love you to write with a fountain. I'd love you to write with ink rather than pencil, etc. And you didn't. There's a possibility I got offended, I went back on it. The caution would be, right, that not to use it until you clarified, even if tactfully. Because when you take it now, it's as if it's a fresh contract. Right? لأنه بمنزلة عقد مستأنف. Right? And this is understood from the same item of the Majalla, 842. Okay. وتنعقد الهبة بقوله وهبت ونحلت وأعطيت. A gift contract becomes, comes in effect by your saying, I gift you, or I allow you, or I am giving you this, right? أعطيت, right? Because the first, I am gifting you, is explicit. I am gifting you, وهبت. The other two are understood by indication, clear indication, because they're used in it. وكذلك أطعمتك هذا طعام. I am feeding you this food. Depending on how it's done, right? Because right? الإطعام قد يكون هبة وقد يكون بالإباحة. Right? So feeding another could be by gifting it or by giving permission. So let's say you have a very temperamental uncle. You have a very fraught relationship. He takes you out for steak. But you don't know, but you really want to eat the steak. So ibaha, they give you permission to eat. Right? Right? So if you want to be careful, so they go to this really nice place, but they give you the steak. So if they order it, it belongs to them. If they give you permission, then they could tell you, go away. Right? But if you, because that's ibaha, they're allowing you to eat. When you go to someone's house, do you own the food on your plate? No, that's ibaha, it's permission. But if but it could also be a gift. This is for you. You take possession of it. That's considered like a gift. Now, alhamdulillah, practically that's where a little bit of akhlaq covers a lot of problems. But in some places it needs to be clear because people take offense. Right? Because when something is gifted, you can take it unconditionally. A permission is limited to the extent of the permission. You can safely take as much as is gifted if it belongs to the other person, right? But when there's ibaha, when there's permission, you have to be careful that the permission, you stay within the limits of the permission. If you overeat excessively, so let's say they ordered pizza at someone's house. Who does the pizza belong to? The host. Okay, free pizza. I'm going to eat as much as possible. So you fasted all day for dinner. I'm going to try to eat 40% of the pizza. That way I don't have to, you skip lunch and you're not going to have breakfast the next day. If that results in the others not eating fully, or goes outside the limits of the permission of the giver, that if they saw you eat like that, they'd be like, there is a dimension there of impermissibility. There's also a thing, if they wanted to stop you, they would, but they may not, they may feel shy of telling you, please don't eat that much. So ibaha requires more caution than hiba. They gifted you, alhamdulillah, take this, right? So there's leftover pizza, they say take the whole box. You can do whatever you want because you own it. So just keep that in mind here. Okay. وَجَعَلْتُ هَذَا الثَّوْبَ لَكَ, said, this thawb جَعَلْتُ هُ لَكَ, that this, I set this aside for you. It means the same thing. وَأَمَرْتُكَ هَذَا الشَّيْء, right? Again, has the same meaning, that this thing, I've made it, granted it to you. حملتك على هذه الدابة إذا نوى بالحملان الهبة. Or, I'm letting you ride on this animal if the person intended a gift. But you can't read the person's intention. Right? That's the other thing. That sometimes they may say one thing and mean another. Now, with respect to the one who intended it, their intention becomes binding. Right? So for example, let's say Sidi Hamza has a fiqh test and he doesn't have a way of getting to the test. So his housemate says, just take my car. Hamza understood that to take my car right now, use it. But the one who intended it said, I have two. And he intended take my car, meaning intending gifting it. So there's an offer and an acceptance. That's a gift. Changing what you intended after the fact, this could be, this ethically, diyanatan, is a ruju' anil hiba. It's going back on your gift. And the prophetic warning, الراجع في هبته كالراجع في قيئه, right, applies, right? Right? So this is an area of ethical caution, right? And the mashayikh would frequently tell us about these cautions, right? Okay, the one who goes back on their gift. It can also apply when you intended to gift something, but then you took it back. Said, this book is for you. Or, hey, this book is, here, take this. And you intended when you gave it, what did you intend? If you didn't explicitly gift it, but then the person brought it back, said, Jazakallah khair for lending this to me. Because they didn't know it was a gift, but they'd taken possession of it. Right? And the hadith, which is in Sunan al-Nasai and elsewhere, the Prophet ﷺ said, الراجع في هبته كالكلب في قيئه. The one who goes back on their gift is like the dog swallowing its own vomit. Right? Right? And in the Musnad of Ahmad, it's a Sahih hadith. الراجع في هبته كالكلب يرجع في قيئه. The one who goes back on their gift is like the dog that swallows back its vomit. Right? And this is similarly narrated in Sahih al-Bukhari and others as well. Right? You can see it there as well. There's many narrations of the hadith. The narration in Sahih al-Bukhari is العائد في هبته كالكلب يقيء ثم يعود في قيئه. Right? There's multiple narrations of this hadith, right? So you can You can see that, right? But the ulama mentioned this also applies in these cases, right? Because what happened when you use that expression? They own it, but you didn't tell them. And when they gave it, they didn't give it because they're actually giving it back to you, right? So that's why these things require. Now they willingly gave it back to you, so it becomes a fuzzy thing, but it's not tayyib, it's not wholesome. Allah. And then he says, وَلَا تَجُوزُ الْهِبَةُ فِي مَا يُقْسَمْ إِلَّا مَحُوزَةً مَقْسُومَةً. Right? It is not permitted to gift that which can be divided except distinct and divided. Right? This is explained in Majma' al-Anhur. أي لا تصح هبة مشاع يحتمل القسمة. You cannot gift a portion of something that can be separated, right? Right? So the things that can be divided, that can be right? Except يعني وهبة المشاع فيما لا يقسم جائزة, right? And the things that cannot be divided is valid, right? So what can be divided, right? What's an example? Let's say two people bought a steak, right? So we went and got a big steak. Is a steak dividable or not dividable? Dividable, right? Now you're willing to share the steak with me, but would you be willing to share it with some random person on the street? Well, it's still all in one piece. Come sit down, let's eat from that, So, to gift something that is dividable, you can only gift it mahuzan maqsuman. Identifying which part, because initially if we buy the steak 50-50, which part of the steak do you own? 50% of the whole. Right? So we say, okay, this is my part, this is your part. So say, well, I've changed my mind. I'm going to have a fried chicken sandwich instead. Okay. So we cut the steak in half. Say, okay, your half, or we divide it. So, okay, this left half, I'm selling. So you say, I'm selling half a steak over here. This half. Also, because one half has a bone in it. It can lead to khilaf. There's a whole bunch of things, right? They may not agree to what part. So it has multiple problems. This is in what can be divided. But in something that can't be divided, we own half a horse, a living horse. How will we divide the horse? Yeah, right? So that's a وَهِبَةُ الْمُشَاعَ فِيمَا لَا يُقْسَمْ جَائِزَةً. Gifting, a shared percentage of something that's not dividable is valid. Can you gift stocks in a company to someone else? Yes. Because let's say you own, let's say someone started, instead of, say, why should Apple be this big tech company? A Muslim decided rumman. It's a more noble fruit than the tufah. They say, who cares about it? Apple is like regular blessing, but rumman is, the pomegranate is greater. So you started Rumman Computers. Or just Rumman Incorporated. Okay? You want to gift your share of Rumman Computers to another. Can you divide Rumman Computers without harm? No. Right? The company. So you can gift things like this and other things, right? A bathhouse, the hammam. So okay, I have 25%. So I'm going to take out all the equipment of the hammam. Then the hammam, the public bath, is no longer benefited from. Okay, so ومن وهب شقصا مشاعا فالهبة فاسدة فإن قسمه وسلمه جاز. If someone gifts a part of something that is divisible without harm, right? Then this is a corrupt sale, a corrupt gift, because it's not deliverable. It'll lead to dispute. But then if they separate it and deliver it, it becomes valid. What's the case? Omar and I bought this big steak, right? We got big steak, making you hungry probably, right? And Omar decides to change his mind. But what he does, let's say this is not Omar Rabbani, some other Omar, because we're not going to ascribe al-aqd fasid to you. So this other Omar guy says, okay, yo, who'd like to get half of this steak for $50? It's an expensive steak. Someone says, yes. Now when you made that sale, you hadn't divided it. Initially, what is that aqd? It's fasid, right? Because he sold a non-specific half of a steak. And you can see, if you actually care about steaks, you see, there's the bone, not every part, like a large steak, different parts of it have different relative values. And it lead to dispute. Right? Any rational person would want more meat and less bone. But there's other considerations. Anyways, but if initially the act was fasid, so this was sinful, but then if you cut it and say, okay, this is the half, and the other person agrees, it becomes validated, right? If you divide it and deliver it and the person accepted it, right, then it becomes valid. And now there's an expression in the sharh, right? It says, وَعِنْدَهُ لَا شُيُوعٌ. Right? What does this refer to? وعنده لا شيوع أي عند القبض لا شيوع. Can you see it? Where it says وسلمه جاز لأن تمامه بالقبض وعنده أي عند القبض لا شيوع. It's not a murder mystery. A lot of the reasoning of the Lubab is taken from the Hidayah. Right? And he mentioned something like that in the beginning. Right? What did he say? Didn't he say something about that? Um, but it's elsewhere. So he doesn't mention the hidayah at all. Anyways, most of the reasoning right? Most of the reasoning, right? 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 The two main sources for what's in there, the legal details are from the Dur and the Hashiyah of and less so, the Hashiyah of Ibn Abdin. And much of the time, those extra, these clarificatory things, he doesn't usually mention it explicitly. And most of the reasoning, not always, is taken from the hidayah, but with great discernment. Sometimes it's from the tabyin elsewhere. Right? So his reliance is on the dur, secondly the hidayah, third on the hashiyah, but less so. And the fourth is the tasheeh wa tarjih of Allama Qasim, right? And Ibn Abdin mentions in his Hashiyah, volume 5, page 519. I don't know why I put this in the. It says, لا يعرف الوجد إلا من يكابده ولا الصبابة إلا من يعانيها. No one knows ecstasy except the one who experiences it, nor passion except the one who beholds it. I don't know why it's there. There may be some context. But that's what the Mashayikh tell us about the Lubab. Right? But why this is useful is when he mentions the reasoning, and sometimes it's terse, then the commentaries on the Hidayah are very good are very useful for unpacking the Lubab. The Lubab needs a lot of unpacking, and that's where Hashiyat al-Laknawi is probably the most useful of the tools for unpacking the Hidayah, because it was written for those studying the Hidayah. Right? Don't get lost in the details of Hashiyat al-Laknawi, but for the diligent student, it is something that when an expression is unclear, right, don't just speculate, confirm. Okay, Bismillah. وفقنا الله وإياكم. ولو وهب دقيقا في حنطة أو دهنا في سمسم فالهبة فاسدة. فإن طحن وسلم لم يجوز. Right? If one, what's daqiq? Right? If one gifts some flour with, that's amongst the wheat. So the daqiq and the hinta, which is the wheat itself, before it becomes flour, or duhnan fi simsim, or you gift some duhun, some oil, and duhun a simsim, with the simsim, and say, I'm gifting you that, but it's mixed together. Right? فالهبة فاسدة, it's باطلة. So even if then, فإن طحن وسلم, then even if you if you need the wheat and deliver it, right, it doesn't become valid. Why? Sorry, daqiq fi hinta. If you gift the flour that is in the wheat, right? If you gift the flour that is in the wheat, or the oil that is in the sesame, it's not mixed with, my mistake. That's the actually in it. The fi is haqiqatan here. My mistake. I got caught up in the previous issue. In wahaba daqiqan, you gift the flour that is in this wheat. Right? So you go to a farmer that has wheat. Say, I gift you the flour that will come from this wheat. You go to a sesame seed producer and say, I give you the oil that is in this sesame. So there's a big thing. and then they extract the flour, they extract the oil and give it. This is not a completion of the first contract. Why? Because just as لا يصح بيع المعدوم لا يصح هبة المعدوم. Just as you cannot sell something that does not exist yet, and we took that at the beginning of the contract of sale, the conditions for a valid sale. يعني يشترط لصحة البيع أن يكون المبيع مالا متقوما موجودا مقدور التسليم. Right? The conditions for a valid sale, it has to be an item of value, of recognized value, for Muslims. مالا متقوما موجودا, it has to exist. بيع المعدوم باطل. مقدور التسليم, deliverable, right? أي بلا ضرر, right? Without harm. So I say, I'm selling you my roof. If I actually delivered you I'm selling the roof of my basement. If I sell you the roof of my basement, what's going to happen to the rest of my house? The whole thing's going to collapse. So that's not, if I actually finally delivered it to you, then that'd be a separate contract, but it's not a valid sale, right? So there, when given, so it'll be valid with the next point, right? The initial offer is not valid, and entering into an invalid contract is blameworthy. It's sinful, right? That's the problem here, because it leads to dispute. Because I have flour. By the time I have wheat. By the time I extract the flour, I realize, you know what? I don't like this guy anyways. Why am I giving him all this wheat? It's hard work. With the economy right now, I don't want to gift it. That's you gifted it to me, right? It leads to dispute, right? So that contract was not valid. When it's actually given, then it would be the contract. Okay, لم يجوز. Because what doesn't والمعدوم ليس محلا للملك, because what doesn't exist is not subject to transfer of ownership. Okay. وإذا كانت العين في يد الموهوب الموهوب له ملكها بالهبة وإن لم يجدد فيها قبضا. If the item that is gifted is already in the hand, i.e. the hand in possession of the one it is being gifted to, he owns it by the act of gifting, right? Even if they don't renew taking of possession, right? Because the item is already in their possession, right? And the qabd is a shart, right? It's a shart, right? And there's some detail about how this applies to sales. We'll leave that aside. وإذا وهب الأب لابنه الصغير هبة ملكها الابن بالعقد. Right? If a father gifts their small child a gift, meaning a known gift, the child owns it by the contract. Right? Because لأنه في قبض الأب فينوب عن قبض الهبة. Because it's already in the possession of the father, so his hand takes the place of the hand of the child, right? And this is really important for parents, right? Because parents are fuzzy, about what their children own, right? And even if one's trying to be cautious, it gets confusing. Who owns that book? Say, okay, this book is for you, right? But it wasn't given to them. The act of giving is considered a transfer of ownership, even if possession wasn't taken. But this is limited by what? By al-ibn al-saghir. Right? Al-saghir, man lam yablugh. Right? So you have to be careful what you give to your child, because then you can't, they own it, so you can't go back on it. Right? You have to be, and the mal, there's entire books written on ahkam al-saghir. Right? And we have in the Hanafi school a tradition of such works. فإن وهب له أي للصغير أجنبي هبة تمت بقبض الأب. Right? If a third party, if a stranger gifts a child something, the gift is complete by the parent taking possession of it. And here, and there's fiqh of it, and it's nicely broken down in, if I recall correctly, in الدرر المباحة في الحظر والإباحة, the issue that parents who receive gifts, quote unquote, for their children, and custom has a role in this as well. Why? Because in some cultures, it's become common for Eid and other occasions, children get material gifts. And the thing to determine is, was this given for the child? If that's what is understood customarily, if it's for the child themselves, then such that the expectation isn't that the parents will be using it, then it belongs to the child. The parent is limited in what they can do with it outside of the direct and clear maslahah of the child, the direct and clear interest of the child. Whereas if it is gifted for the child, meaning I'm giving it to you, use it however you see fit for your child, then there's more leeway. You could spend it on grocery, etc. as well. If it's clearly like that. That this is for your children, right? Meaning, if it meant that, you have, Bilal has 8 children that he's raising, etc. Here's something for your children. Is it meant that, okay, I'm giving you $800, $100 for each child? Or, what's understood? That, things are tough right now. I'm giving you $800 for your children, meaning provide for your children. So there he could use it. So the basic thing is, who owns it? Is the transfer being made to the children? Is the transfer being made to the parent? There's categories of amwal, that is, and we're coming to the chapter on the waqf, on endowment. There's some types of amwal that are based on caution. Malul yatim. Okay, the money that is for the orphan. Mal al-waqf. An endowment. Like an endowment are public funds in our times, right? The Mukhtasar al-Khairiyya, that's based on caution, because the mal al-waqf, that money is set aside, can only be used in that particular manner, right? And we'll see what those rulings are. The public money it has to be serving the public interest, and it's very risky because everybody has a non-specified claim on it, right? So it requires caution. The mal al-saghir, the money of the child, is also based on caution, right? So there are 2 clear situations where it's clearly given for the child, either صريحا or بدلالة العرف. Where it's clearly given for the child, then it's clear. It now belongs to this money is the child's, the parent has no right of other disposal of it. Or where it's clearly given to the parents, either explicitly, They said, "This, I'm giving this to you. Spend it on your child." Right? But it said, "Is it for me?" Yes, it's explicitly, or by dilalat al-urf. In this context, this is given for the child, customarily. Like, for example, in many countries, the government gives people below a certain threshold, or unconditionally in some other countries, a child benefit. Who that child benefit is for whom? Right? Someone has a newborn child. That couple of $100, does that legally belong to the child? No, it's given to the parent. It's a child benefit. It's for that child. But whose ownership is it? Parents. They can use it. They don't have to use it just on that child. Right? So there are two. One case where it's clearly for the child. Other is it's clearly for the parent. Whether that clearly is صريحا أو دلالة, right? Explicitly or by indication of the urf or of the context. Then there is in between where it's unclear. The caution for the parent is to consider, the initial assumption would be to consider that it belongs to the child. It belongs to the child unless one makes bayan, unless one pauses and considers. Right? And it requires ihtiyat, it requires caution. Right? And يكون البيان من صاحب البيان. One of those to ask. So, but it can be awkward, right? You have to ask the grandparent. So, did he give that money to the child themselves? And people who are uneducated Islamically, for example, or unaware Islamically, they may think you're being weird. So, where you can't make bayan, then you have to use ghalabat al-dhann, but you err on the side of caution. Right? As we know, لا يحل مال رئ إلا بطيب نفس منه. Right? The property of another is not halal except with their willful permission. وإذا وهب لليتيم هبة فقبضها وليه جاز. And likewise, if a gift is made to an orphan and their guardian takes possession of it, this is valid. And the gift is complete. Right? فإن كان في حجر أمه فقبضها له جائز. And if the orphan, who's lost in this case, presumably who's lost a father, is with his mother, then her taking possession on behalf of the child is sufficient, is valid, it's sufficient. Right? وكذلك إن كان في حجر أجنبي يربيه. And likewise, it's valid for a third party to take possession of it if they're being raised by them. Right? So, for example, I have some friends who have like large families, they have 4 or 5 kids. So they've sent some of the kids to the grandparents, for example, or to a sibling. Can you take care of 2 of my kids? Someone makes a gift, they can take possession of it, but it belongs to the child. You can't say, okay, well, I'm feeding them, so I'm deducting the money that I'm feeding them with. They can't do that. Right? فَقَبْضُهُ لَهُ جَائِزٌ. So taking possession on behalf of the child is permitted for them. Right? فَإِنْ قَبْضَ الصَّبِيُّ الْهِبَةَ بِنَفْسِهِ جَائِزٌ. And if the child takes possession of the gift themselves, it is valid. Right? This is إِنْ كَانَ مُمَيِّزًا. If the child has reached the age of discernment. Right? That's important. Right? And then he says, وَإِنْ وَهَبَ إِثْنَانِ من واحد دارا جاز. Right? If someone gifted, if in وهب اثنان من واحد دارا جاز. وإن وهب واحد من اثنين لم يصح عند أبي حنيفة. Right? وقال أبو يوسف ومحمد يصح. What is the scenario here? إن وهب اثنان من واحد دارا. The اثنان are the wahib. If two gifted a property to one person, this is valid. How? The house is owned 50-50 between Umar and me. Right? Of something that's dividable. Right? You could divide it's a property, we could divide it in half. Right? It's a divisible property. Right? Or the stake. Two of us gifted the stake to another person. We got the stake, say, you know what, I actually don't want this stake. Actually, you know what, I don't either. It's big but doesn't look tasty. So if the two of us gifted it to somebody, it's divisible, we didn't divide it, we gifted it to another person. It's valid. يعني لأنهما يعني الواهبان سلماه جملة وهو قبضها جملة فلا شيوع. Because we gifted the whole thing, because we both own 50%. Right? The problem is لا يجوز هبة الشائع فيما يقسم. So the stake. Right? Let's leave the property aside. Let's go back to our stake example. Umar and I got this big stake. He said, I don't want it. I said, you know, I don't want it either. I'll have those spicy tacos. We saw this guy standing there looking hungry. I said, why don't we gift it to him? The two of us, gave it in one go. So there's no shared things. It's not going to lead to dispute, this, that, which part, etc. فلا شيوع. Right? فإن وهب اثنان, that's the wahib. Right? اثنان من واحد, من واحد أي إلى واحد or لي واحد. Two gifted من واحد, they gifted it to one person. Right? Right? وإن وهب واحد من اثنين لم يصح عند أبي حنيفة. Right? If someone gifted one of two things, right? What's the scenario here? And this isn't something dividable, right? So I gifted my share of the stake, right? To another person. لأنها هبة النصف من كل واحد منهما فيلزم الشيوع إذا وهب واحد من اثنين لم يصح. Right? So we own, something is shared between two people. One of them gifted their share. Right? It's not valid because they gifted half of the whole. So this is the shuyur. Right? And the opinion of the Imam is preferred here. Now then, here There's the issue of الرجوع عن الهبة, right? And you can see items 864 and 865 of the Majalla, right? Right? So he says, right? So here there's two things. إذا وهب هبة لأجنبي فله الرجوع فيها إلا أن يعوضه عنها أو تزيد زيادة متصلة أو يموت أحد المتعاقدين أو تخرج الهبة من ملك الموهوب له. Okay. If someone gifts another and the gift is complete and they take possession of it, the gifter has the right of going back on it. Meaning has the legal right. Right? 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 Has the legal right. فَلَهُ الرُّجُوعِ أي, this is the hukum. له, that they have the right to do so, but مع الكراهة كراهة التحريم. This is إثم. كراهة أي التحريم. Prohibitively type. Right? لقوله صلى الله عليه وسلم العائد في هبته كالعائد في قيئه. Right? And there's two and the wording of Bukhari and Muslim is العائد في هبته كالعائد في قيئه. Right? With similar wordings, right? The one who goes back on their gift is like the one who returns on their. But how does this work, right? How does the taking back go? The Majalla mentions that the taking back either happens with the rida of the one it was gifted to. They either agree to take it back, to give it back. But if they don't agree, then it is taken to court. And then the judge could annul that. It has to be established that this was a gift, etc. So they'd have to establish the proof, etc. Right? Why? Because something was given, right? Now they ask for it back. That could cause the other person significant harm. They say, no, I don't accept to give it back. It's okay, let's go to court. Or let's go to tahkim. Right? But that applies to the hiba. That's items 804 and what? 864 and 865. You can see the items there. But 874 of the Majalla clarifies that لا يصح الرجوع عن الصدقة بعد القبض. You cannot go back on charity after having given it. بوجه من الوجوه, in any way whatsoever. And it's discussed there, and you can find that this mas'ala, one of the useful things that's neglected is we have two great legal commentaries. I mean, there's many good commentaries in the Majalla. The two great legal commentaries are Al-Atasi and Shaykh Ali Haydar, rahmatullahi alayhima. But if someone is spending time in fiqh al-mu'amalat, don't neglect Rustum Baz, because Rustum Baz really puts primary focus on Majma' al-Anhur and Hashir ibn Abdin. So very often you'll find quotes in there that Ali Haydar and Rustum Baz, and he's very good at, he summarizes really well. But another text that is very useful, because sometimes you wonder, where did they get this from? Right? There's a work called Mir'atul Majalla, which basically focuses on what are the texts that this is based on. It's useful. Okay. إلا أن يعوضه عنها, unless the one who received the gift gives something in exchange. So, give me back the copy of Ihya Ulumuddin. So he said, here's the market value of it. Assalamu alaikum. Right? Right? أو تزيد زيادة متصلة, or the item given has a زيادة متصلة. Right? Right? Someone gifted someone land, but they built upon it. Right? Or they planted trees on it. زيادة متصلة. That it's an increase that is inseparable without damage, and that increases the value. Then you can't go back, right? Right? And you can read the details. What about a child, etc.? That's not a ziyada muttasila. أو يموت أحد المتعاقدين, or if one of the two parties dies, then you can no longer go back on a gift, right? So the father gave a gift. The inheritors can say, "Oh, he gave it to you, but we all hate you. Give it back." And actually, things like this sometimes happen. Someone had an ex-wife, and he'd given her the house, and then the children of the next wife say, "That belonged to dad. He gifted it to you. Give it back to us." You can't do that if either party died. أو تخرج الهبة من ملك الموهوب له, or if the one who was gifted it to someone else, right? So if you got a gift from a temperamental person, one of the ways you could prevent them having the right. So Bilal is a temperamental, hot-headed friend of mine. He gifted me a copy of a rare book. I took possession of it. I'm worried he'll want it back, because he doesn't realize that this manuscript's worth $500. So what do I do? I sell it to Omar for $10, and he sells it back to, or then he can gift it back to me, or but proper with transfer of ownership. Then he asked for it back. Said no, it left my property. خلاص انقطع. Then even if it comes back to me later, you can see how you to do that. أو تخرج الهبة من ملك الموهوب له, even if it came back after, and you can see that. وإن وهب هبة لذي رحم محرم منه فلا رجوع فيها. If one gifts to an immediate family member, then there's no way of going back on it, right? Right? Because there is a maqsood from it, which is sila, and it has happened. And also because of the greater damages it has. وكذلك ما وهب أحد الزوجين لآخر. And this is something that's frequently ignored, right? Right? This is tanbih, right? And likewise, what one spouse gives to another, because there's a meaning here of sila, of maintaining of ties, and that purpose is fulfilled. So it's not mujarrad tabarru', it's not just mere giving. And this comes up in divorce cases. So this intelligent woman, if she received gifts, like what the gift she receives before marriage, they could demand them back, possibly, but it would be khabith, that would be vile, right? But what she received after marriage, they couldn't go back on at all because of this, right? But this leads to all kinds of problems. So what's given before, right? And then there's fatwa related to that. One can look at it in its due place. It becomes messy. That's why simplicity saves a lot of trouble. Don't. Okay. وإذا قال الموهوب له للواهب خذ هذا عوضا من هبتك أو بدلا عنها أو في مقابلها فقبضه الواهب سقط الرجوع. Right? If the one who received the gift said to the gifter, right, take this in exchange for your gift, or as payment for your gift, or for your gift, and then the gifter takes it, then now there's been an exchange. So then there's no returning. Right? If they connected it. Right? So someone said, here, so you really like my phone. You don't think I'd give it to you. And you're an unrelated person. So I gave my phone to Zayn. I said, I gift you this phone. So Zayn wants to be smart. He said, man, I get this nice phone. So I said, okay, in exchange for the phone, I'm giving you this gift. And he gives me the gift of a book. Right? This is considered now an exchange. I can't take, even in court, I couldn't take back that gift. So that's another way of shielding yourself from the returning of gifts. Right? وإن عوضه أجنبي عن الموهوب له متبرعا فقبض الواهب العوض سقط الرجوع. And the same thing would happen if a third party compensates on behalf of the one who received the gift without being asked, even without being asked, and the gifter took that compensation, then the gifter could not demand the gift back. Right? So let's say I gifted my phone to Zubair. We gifted it. Zubaydah knows her fiqh. So she says, in exchange for that gift that you have given my husband, I gift you this copy of Sharh al-Shama'il of Mullah Ali al-Qari. And I took it. She's a third party in our transaction. Then I couldn't demand the phone back. It doesn't have to be the same value or the price. Right? And in this case, where something was given in exchange for the gift, وَإِذَا اسْتُحِقَّ نِصْفُ الْهِبَةِ رَجَعَ بِنِصْفِ الْعِوَضِ. Right? If half the gift, now it turns out الاستحقاق هو ظهور حق ثالث. Right? This istihqaq is if it turns out that the item gifted had a right in it of a third party. So half of it, for example, in this case, half the gift belonged to someone else. The phone was actually shared between me and Umar. And the person gave $50, said, because you gifted this, I'm giving $100 as a gift to you. But turns out that you only have 50% ownership of the phone. Then the one who gave that compensation can demand 50%. So half of what was given, $100, they have right to 50 of it. When استحق نصف العوض لم يرجع. But if the amount that was given turns out to belong to a third party, then the gift لم يرجع الواهب في الهبة. Then in that case, the gifter cannot go back on their gift. So what's the case? I gifted the phone to Zubair. They gifted me the Sharh of Mullah Ali al-Qari on the Shama'il in exchange, but turns out that the Sharh of Mullah al-Qari was half owned by Sidi Hamza. I took some consideration anyways for that, so I can't go back on the gift that I gave, which is the phone. إلا أن يرد ما بقي من العوض, unless I give back what remains of what I took, right? So they gave 2 books. One of them turned out to belong to another person. I gave the other book back too. Then I would have the legal right to demand the gift back, but we said it's a legal right, but morally it is makruh tahriman. And the person does not have to accept to give it back unless it's taken to court, right? And then, right? That's why he tells us, وَلَا يَصِحُّ الرُّجُوعُ فِي الْهِبَةِ إِلَّا بِتَرَاضِيهِمَا أو بِحُكْمِ الْحَاكِمِ. It is not valid to demand that the person return the gift except by their taradi, by mutual agreement. إلا أن تكون تجارة عن تراض منكم أو بحكم الحاكم, or by the judge, the ruling of the judge. But they say كل مال أخذ بسيف الحياء فهو كل مال أخذ بسيف الحياء فهو حرام. The early Muslims used to say this. All property taken by the sword of shyness is impermissible. Right? So let's say Sidi Hamza has protein samosas. They look like samosas, they taste like samosas, but they're actually really healthy. It's not fried potato. So that he brings these, it's part of the progressive Indian culinary movement. He has these butter chicken samosas. And he brings that's the only thing he'll eat all day. So, Zubair and Zubaydah come and say, Hamza bhai, how are you doing? Can I take one? And they're already stretching hand. Hamza feels shy. So Zubair and Zubaydah take one. Then Omar says, me too. Well, he doesn't want to look like a loser. So Bismillah. And Zayn said, doesn't even ask. He takes one because everybody's taking it. So Sidi Hamza calculated to, he needs 2,100 calories a day. That was his one meal. Poor guy's left with one little samosa, He didn't say no to anybody, but it's called Sayful Haya, the sword of shyness. That's where transactions are complicated, that you force someone into a situation, فَهُوَ مَالٌ فِيهِ خُبْث. It's not khabith, but فِيهِ خُبْث. Right? It has a degree of vileness in it, which is why even in negotiating, the righteous will be careful in negotiating, because when you bargain hard, the person may agree out of shyness towards you. So it is mentioned. So the righteous, even recent righteous, would be very careful in bargaining. Imam al-Kawthari, when he would go shopping, and he was, especially once he was in Egypt, he was of very limited means. He lost all his property, he lost his library, but his memory is spectacular. He would mention things that he'd seen in libraries. Some people thought he makes things up. How does he know about libraries, in manuscript libraries all over Turkey? When did he go there? But he was a truthful man, rahmatullahi alayhi. Imam al-Kawthari would go, and he had very limited means. Towards the end of his life, when he got sick, rahmatullahi ta'ala alayhi, he started having to sell off the books that he had to be able to pay the medical bills for his wife and then his own living expenses. He had to get rid of his own books. So he never took any money for his own publishing. He didn't even take the copies of the books that they would typically give the author. He wouldn't make money on his books, but he also, typically, publishers would give a certain number of books to the author to give out, and he would sternly refuse that. And Imam al-Quduri was given to sternness, and he would say, هل يجتمع هذا الأجر مع أجر الآخرة? Will this reward be found with the reward of the hereafter? And he would sternly refuse. And al-Quduri's biography is worth reading, rahmatullahi ta'ala alayhi. But it's mentioned in his biography that one of his akhlaq was he would not negotiate when he purchased. He would go, make an offer. If the person agreed, they agreed. If he didn't, he would walk away. And they would try to negotiate with him. No. Because he didn't want to take anything to save. That was, and this is in societies where it's normal. People give a surreal price and you have to negotiate it down. Now, of course, we know باع رسول الله صلى الله عليه وسلم بيع من يزيد. The Prophet صلى الله عليه وسلم engaged in bidding. Right? That's part of trade. But there is a khuluq there of not over demanding, right? This applies in sales contract, also applies in hire contracts. Right? You overwork your employee, etc. And say, for my sake, this and that reaches the level of ta'addi. Right? They agree to 40 hours, you demand. Now they willfully do extra, but that's a very sensitive thing. Right? Did they agree to the overtime, etc.? You have to be very, very careful. Nasallallahu al-afiyah. So we'll stop there. We'll complete the chapter on gifts. I would encourage you to read hadiths related to gifts, bi'ithnillahi ta'ala. Something worth sharing the link to. Now you don't need to read the whole sections and so on, but to get a taste of this, just we'll share the link to the work. It's there on archive.com. إعلام الأنام شرح بلوغ المرام of Dr. Nuruddin Itr. The chapter on gifts. Bulugh al-Maram is, of course, the hadiths presented in Bulugh al-Maram primarily give the Shafi'i side of things, but it's good to know. But it's a good sized, mid-sized work. It's about 1,600 hadiths all said and done. It's accessible, it's brief. He references it, so it doesn't bring in the asanid and so on. So it's accessible in many ways. Dr. Nuruddin Itr has a very good legal commentary, and also it's a convenient way of accessing what the other madhahib say, reference back to their books. He also brings in the wisdom of legislation and so on. We'll just dip there and see some of the ethical framing of the section on gifts. There's also, of course, a prophetic encouragement. The hiba, but the hadiyah, that which is done within family, amongst friends, and in other such contexts, tahadaw tahabbaw. Exchange gifts and you'll grow to love one another, right? And that's frequently neglected. It indicates mutuality. But the adab is, you give without expectation. You give without expectation, right? To attain the full reward. But if someone does good to you, فَكَافِئُهُ مَنْ صَنَعَ لَكُمْ مَعْرُوفًا فَكَافِئُهُ. Anyone who does good to you, then reciprocate. أو بأحسن منها, or better than that. But of course, remaining within balance. Like, one-upmanship in gifting is against the sunnah. You gift a small book, you gift a mid-sized book. Then you gift a big book. You gift an encyclopedic book. You gift your library. You bankrupt yourself. No. So it's not like that's takalluf. Bila takalluf. So we'll stop there. وصلى الله على سيدنا ونبينا وحبيبنا وقرة عيننا محمد وعلى آله وصحبه وسلم. We're going a little slower because there's no point in rushing through a text without really trying to get many of the practical issues and the ethical dimensions, the practical ethics, and I hope you find benefit in that. But we pointed to a number of areas in the majalla that are important and touched upon a few of the things, for example, where you can go back on gifts and where you cannot and so on. These are important points. Any questions here?
The text reference to in Mir'at al-Majalla, is this like sources from the Quran and Sunnah or fiqh references?
No, the fiqh references.
Stevie Zane's asking, what's the ruling of giving a gift back out of your own accord?
But again, that giving the gift back is like returning something. The other person needs to accept. I insist that you take back the gift. Right? Right? لا لزوم إلا بالتزام. Nothing is required except if you take it on. Right? Right?
Zane was asking, what's the ruling of offering to buy something you gave back?
Taradi. Offering to buy something you took back. What's the example of that? Right? It's best, to think things through clearly. That's why, they mention these, the wadha'if of fiqh. Like there's, fiqh has 7 or 8. You can number it in different ways. But one of the neglected things that Tullab ilm don't do, and we've tried to do it throughout here, and it may look sometimes funny, the issue of entrepreneur sister and so on, and the stake and so on. But it's tamthil. You understand something bil mithal, right? By examples, right? And Allah gives examples to us. He doesn't just give us abstract things. Why? Because it makes things clear. Okay? وَيَضْرِبُ اللَّهُ. Why? Right? Allah subhanahu wa ta'ala tells us a whole range of reasons why amthal are done. And it ultimately goes back to what? So that they may understand and discern and realize and recognize, etc. There's all. Any other questions?
There was someone saying, Shaykh, you explained when وهب واحد من اثنين لأنه حيبة النصف as a case of a shared item between two people where one of those two give their portion to another person. Does it not mean one giving to two?
إن وهب اثنان من واحد. What?
It's the next one.
Okay. So وهب اثنان من واحد is very clear, right? لأنهما سلماه. The اثنان are the واهب. اثنان أي واهبان من واحد, right? دارا من واحد. This is the موهوب. دارا, right? وإن وهب واحد من اثنين, right? Same thing. الواهب الواحد and من اثنين, someone gifted one thing to two, yeah, so it's the same thing. It's in reverse. If one gifter gifted to two people, لم يصح عند أبي حنيفة لأن هبة النصف, because it's gifting half من كل واحد, فيلزم الشيوع, because you're gifting something that's shared. So what's the case? I give this steak, I'm giving this steak to you too, and it's divisible. Why? Because it'll lead to dispute. right? It'll lead to dispute. What am I gifting to you, and what am I? Because you're two different individuals. If it's a company, I gift the company the stake, and then what they do with it, right? That's a different thing. But I gift it to two separate individuals. It's going to lead to dispute, and there won't be في زوال وصف التراضي, right? According to Abu Hanifa, because what did I gift you is this the issue of hiba to sha'i'. This is a fara of the hiba to sha'i' فيما يقسم. Right? This is an application of the previous principle. So properly speaking, I said I give you this half, I give you that half. Right? But the Sahibain said it is allowed. Right? It is allowed. And if you ever have children, like, okay, this, especially, but practically, here knowing the position of Sahibain, because people do this frequently, right? You get, for example, there's 3 teenage kids, and you got a lamb shank. Say, this is for you guys. I gift you give it to them. Different parts of the lamb shank have different value. So Omar, you can take the bone. Would you be fine with just the bone? No. Right? But practically, the position of the Sahibain, and you'll see that there's many who've given that. Because ultimately, the whole thing was given to them. Or just so you can, but the safer thing is to divide that. But then you can say, فيما يقسم, is the lamb shank divisible, etc.? Right? So this is فيما يقسم. Right? The cake. Right? Right? The cake. Is the cake divisible? Yeah, very good. Any other questions? Okay, let's stop there, inshallah. Sallallahu alaihi wa sallam. Muhammad wa alihi wa sallam.